Evening's panel event here at the Royal Society of Edinburgh, and also welcome to all of you online who are joining us as well. It's great to see you here, and we have been warned that, unsurprisingly, there are a number of trains delayed, so we may well have people just joining us a little bit later and coming up, so do make room for them on the edges if you're able to do that. My name is Alison Phipps, and I am the convener of the United Kingdom and Ireland Academy's Human Rights Committee. I am looking at my notes to say that because Ireland has recently been brought in to the group. But this is a committee that has been meeting now for many years to really ensure that academics who are at risk of persecution, who may have been imprisoned unlawfully, who are being persecuted for their academic freedom, that they are aware that there is a network of scholars around the world who will act and raise awareness of their cases through the appropriate channels. And so today's event, this evening's public event, is the last event of a long series of meetings and workshops that we've been having, hosting the UK and Ireland Academy's Human Rights Committee today. And we've had a very stimulating afternoon thinking about human rights. But the Royal Society of Edinburgh was very keen today to host an event that would mark the anniversary of the Universal Declaration of Human Rights, which is 75 years old this month. And to do so at a time when human rights are, as we are all palpably aware from our TV screens and our social media feeds, at great risk and grave risks. And to do so the day after the Secretary-General of the United Nations has invoked Article 99 for the first time during his tenure. And invoking Article 99, the Secretary-General is bringing to the attention of the Security Council any matter which, in his opinion, may threaten the international peace and security. And that he has done so by stating that he is concerned there is a severe risk of collapse of the humanitarian system in Gaza, that the system is fast deteriorating into a catastrophe with potentially irreversible consequences for Palestine as a whole and for peace and security in the region, and that such an outcome must be avoided at all costs. And I'm naming that now because that is the context and the backdrop to much of what is on people's minds when they are thinking and concerned about human rights today, not least because human rights were born out of the dreadful conflict of the Second World War and the Holocaust, that imprescriptible event with devastating consequences for Jews, for homosexuals, for academics, and for Roma people in particular. So we're gathering today in the spirit of, yes, marking, if not celebrating, the Universal Declaration of Human Rights, but also bringing together two key scholars working in Scotland, Professor Nasser Mia, who is Professor of Social and Political Science at the University of Glasgow and a Fellow of the Royal Society of Edinburgh, and Dr. Deval Desai, who is Reader in International Economic Law at the University of Edinburgh and who is a member of the Young Academy of Scotland. And they'll be joining myself to discuss aspects of human rights in law and life. I hasten to say that neither Nasser or myself are human rights lawyers or trained lawyers in any way, but we're delighted that Deval is joining us and bringing his legal expertise and also the global perspectives that he brings because of the necessity of the clarity that we gain from the many lawyers who've worked on human rights and the related areas over the years, but also acknowledging the work that many academics engage in and the way that human rights pervades our lives, our everyday, ordinary human lives. That, to quote one of the panelists in one of our events this morning and this afternoon, human rights belong to us. They are not just a good which belongs to the lawyers. They are something for all of us to care for and to sustain. And that it is in that spirit that we have wished to bring forward an event which looks at human rights in law and life. Equally, this debate and the panel form part of the consultation group, a very august group containing, it felt like 10 law lords, though I think maybe it was a one or two fewer than that, but who came together, a group of academics and a group of lawyers, to do a consultation for the Royal Society of Edinburgh on the Human Rights Bill for Scotland. And this drew together a panel of leading thinkers, Nasser and Deval being two of them, many contributing to marking the significant 75th anniversary of the Universal Declaration of Human Rights. So this panel is made up of those who were part of that consultation, and I know that some are also in the audience, and we're delighted that they too have been able to join us today to focus on the space for action that is available to us all, and also for reflection of the Academy nationally and internationally. We're focusing very much on the highly contextual nature of human rights practice globally, and on the room available for human rights as technical legal practice, alongside what we might term, following the great scholar Laurent Berlon, and also the work that my colleague Nasser Mir has undertaken in the field of racial justice, what we might call the cruel optimism of human rights. We're looking at those who have never enjoyed the right to have rights, as Hannah Arendt has termed it, and the tantalising concept of human dignity as a legal and lived experience. And that concept of human dignity has been central to the consultation the Scottish Government has done on the Human Rights Bill Scotland. So the panel is resolutely situated within the human rights struggle of the present moment of conflict and contestation, seeking to offer a space for reflective practice and the discomforts that come with the many contradictions that are within the field of human rights. And we invite you as audience online and as audience gathered here to reflect on what different appeals to human rights might mean today in your own contexts and fields of practice. And also in language, what language you find helpful, what you might find unhelpful or feel is shifting or difficult today and in the global context. And this includes the key question of how we can foster and also critique human rights approaches in contexts that are now, today, 75 years on, very different to the inception of the Universal Declaration of Human Rights. For those of you who are interested to read the consultation that we undertook from the Royal Society of Edinburgh, there are handy QR codes. Prior to the COVID pandemic, the QR code was really not a thing, but obviously now it's what we use all the time. And you can scan, these are up on the wall, you can scan these if you wish to read the consultation, or you can search on the Royal Society of Edinburgh's website and you'll find that consultation response on the policy briefings. I'd also just like to note that we're really keen as a panel to slow things down a little. The context of human rights discussion, particularly at this moment in time, is heated, fraught, highly contested, and there are many words traded which can potentially bring more harms in future and tear at the fabric of our language and also at the fabric of our understandings. And as academics, we have on our side the ability to slow things down. We were reflecting this afternoon that it is often something of a frustration to NGOs and human rights activists, and even to our politicians, that it takes a few years for our articles with their careful referencing and rigorous scholarship to come out. But that slowing things down is one of the things that we can bring as academics to the debates around human rights. That where there is heat, we might be part of bringing cooler heads, slowing things down, maybe helping us not act too much in haste, and allowing there to be room later for reflection in writing, but also reflection on what it means to hold many different kinds of silences. And I think this is something we may in the panel come to reflect on, but certainly is something I'm reflecting on at the moment in this present moment. But we would also like to claim the many freedoms that we have in a country that is a democracy, that has a Human Rights Act within the UK, where there is a human rights bill under consultation at this moment in Parliament, and where in Scotland, and where we are also protected by many international treaties, all of which have been byproducts of and emanated out of that Universal Declaration of Human Rights. Be they around our cultural rights, be they around treaties, be they around the conventions protecting refugees, or the conventions around war crimes, around genocide, and the many different groups who are working collectively at this moment in time and who have worked tirelessly over 75 years, collectively, to ensure that when we do act out of a care and concern for human rights, that we do not necessarily do this alone. At the moment, there are 800 scholars of genocide who have made clear their grave concerns about the possible situation within the Gaza Strip. There are 18 United Nations agencies who have made clear their concern regarding humanitarian and particularly medical collapse. There are a range of trade unions who are protecting academic and academic-related staff and also students, and that when we feel as though we're alone, it's good to remind ourselves of the many places in the world, but also within our own context, where actually our freedoms are upheld by other colleagues or by other people, also with regard to our own situation in the United Kingdom. And so with that in mind, and with that collective celebration I think we can make of the context in which we work, I'd like to hand over to my colleague Nasser to hear his words. Thank you.
Thank you, Alison, for that very generous introduction. Good evening, everybody. It's a pleasure to be here. Alison suggested we introduce ourselves with something of a biographical character to it. And I suppose that in doing so, I'm reminded that one of the ways in which we encourage our students to develop an intellectual or a sociological imagination is to think about how their identities, their seemingly private, personal status is often connected to the world beyond it, you know. So people who may have household debt can't see that apart from a broader political economy. People who feel shame can't understand that without reflecting on the prevailing moral order. When academics try and do that, we're less good at it. But when we do, we quickly discover that sometimes our topics choose us as much as we choose them. In my case, I'm the son of a child refugee who became so during the partition of India in 1947, and with a family that moved from northern India and Pakistan through the Gulf states all the way to the Pennines in West Yorkshire, the home, of course, of Alan Bennett, the Bronte sisters, Barbara Hepworth, and chicken tikka masala, which is contrary to some erroneous claims made in Glasgow. Like many others, my father worked in the textile industry. He was a trade unionist, a shop steward, formidable organizer and canvasser. Unlike my mother, who came from Lahore, he did not return to Pakistan in his lifetime and never resaw his childhood home. So I think it's inevitable that, and perhaps predictable, that our areas of research then often reflect our biography. In my case, displacement, identity, and topics of research on migration, which is what I do at the University of Glasgow as a social scientist. So I think it was on the 5th anniversary of the UN, of UDHR, that Dag Hammarskjöld, who was the second Secretary General, is quoted as having said that the purpose of human rights is not to get us into heaven, but to save us from hell. And the realism implied in that sentiment has been sitting with me over the last few weeks whilst we've borne witness to the ordeals of people seemingly going through their own kind of hell. To bear witness from our relative comfort apparently is called vicarious suffering, which strikes me as a little bit perverse when set against the first-hand suffering of civilians the world over, especially in Gaza, people trapped amidst the debris, where children have been heard to plead with rescuers to leave them in favor of rescuing their parents and their siblings, or the ordeals of young people and families who survived the violence inflicted on them in the adjacent kibbutz. I very much doubt I'm the only person in this room who wishes that they could unsee and unhear this suffering, or has held their loved ones a little closer because of it. And so one obvious question then is, how has this come to pass, given the patchwork of human rights and international humanitarian laws that have been stitched together over the last 75 years? Now, these are two distinct, but I think complementary bodies of law, and especially so when we bring together how they're concerned with the protection of life, health, and the dignity of individuals. A second question I'd like to reflect on is different, but also invites us to reflect on the identity of human rights. Can something fashioned by colonial powers in 1943 with no African representation on the drafting commission truly be universal, or is it one idea of the universal? And I think reflecting on that, I think is important for the meaning of dignity, which we spent a lot of time reflecting on in our response to the bill currently in the Scottish Parliament. So my thoughts on the first question very much proceed from my approach to thinking about justice rather than the law, in particular racial justice, and that gives us a qualified answer. Qualified because what working on justice makes you appreciate is the glaringly obvious gap between the optimism of what human rights appeals to and the grim realities and the political expediency in which they must. Qualified because whilst most universally accepted documents of human rights and international humanitarian law have been developed, as Alison said, on the back of atrocities, and so they reflect an ambition not to repeat them. It's precisely the belief in the progress through incremental advance that can sometimes create the sense of optimism's double bind, almost an impasse that doesn't really allow us to detach from already repeating what is not working, to quote Laurent Ballon. Now, one very important example, of course, is the role of state practice, particularly the practice of powerful states, in promoting what is or should be legal in the context of war and armed conflict. So here the issue becomes the nature or the amount of the legitimacy some governments derive from their appeal to what might be deemed lawful, the intellectual and the political labor that more law-conscious states expend to frame their violence as legal with times of the invention of new conditions or responding to new conditions. Now, one of the reasons I was always much more drawn to an understanding of justice was that it allows us to see the social production of a kind of moral indifference in developing interpretations of what becomes deemed lawful. And with it, we cross the Rubicon often in ways in which normalizes as necessary what the spirit of human rights law and international humanitarian law should guard against. Customary international law, according to the International Committee of the Red Cross, derives from a general practice accepted as law, and that the international community believes that such practice is required as matters of law, end quote. The Financial Times yesterday reported that more munitions have been dropped on Gaza than were dropped on Dresden and Berlin during the Second World War. Half of the population that received them were children. Permitted despite the principles of distinction, proportionality, necessity, humane treatment. Can international human rights and international humanitarian law retain their integrity? Or is this just a reflection of the politics of law? Discuss. My second set of comments for a conversation concerns the identity and the implications of human rights today. And I think this means pluralizing human rights approaches by recognizing other perspectives too, especially from the global south. Now, there's a deeper argument here, I imagine Deval will excavate, about the contingencies of law's grounds, and that while the world is diverse and multiple, law has to have a common foundation, for there's no authority which can exist outside that. Now, I'm skipping over this more challenging point to the more modest one, which in the justice literature is sometimes called a third-generation norm of legitimacy, namely respect for reasonable cultural diversity, which needs to be considered on a par with the first and second generation norms of freedom and equality, and which in turn become modified by the third. The implication of a third-generation norm of legitimacy for a concept of human dignity is that for the UDHR version of human rights to be meaningfully imbibed outside the context in which they were created, requires them to better connect with the culture and the circumstances in which they're received. We'd rightly consider the UN Declaration as a kind of moral minimum that's due to and from human beings to one another. But people don't experience their lives in these terms. For example, respect for human dignity requires that we should not humiliate, degrade, or demean. But in many societies, that includes the recognition that life consists of groups as well as individuals, and that both need to be provided for in the formal and informal distribution of power, not just in law, but in representation, the offices of state. One of the most famous sentences of the Bangkok Declaration of Human Rights, signed in 1993, I quote, is that while human rights are universal in nature, they must be considered in the context of a dynamic and evolving process of international norm setting, bearing in mind the significance of national and regional particularities and various cultural, historical, and religious backgrounds. In contrast to the UDHR, which is a document that enshrines rights, the African Charter also includes duties, asserting that every individual shall have the duty to respect and consider their fellow human beings without discrimination, to maintain relations aimed at promoting, safeguarding, and reinforcing mutual respect, tolerance, and duties towards the family, as well as society. The Cairo Declaration in 1990 can be considered a much more comprehensive alternative to the UDHR because it enshrines different values and another understanding of some basic human rights and fundamental freedoms. I quote, "It's the duty of all states to support the struggle of colonized peoples for the liquidation of all forms of occupation, and that all states and peoples have a right to preserve their independence and control of their wealth and their natural resources." Very different orientations of what universal human rights might be. On the one hand, then, the fact that different communities of states have adopted other specific documents, I think, is a testimony to the richness of the contemporary appeal and desire for human rights. But I think they also potentially reflect the parochialism of the UDHR. And I think in context of democratic backsliding, a kind of popular authoritarianism, I don't think appealing to human rights as a base standard is necessarily sufficient without having a broader idea of the human, I suppose, in what human rights are. I'll stop there. Thank you very much.
Thank you, Deval.
Thank you, Alison, Nasser, for those really thought-provoking remarks, to the RSC and to the organisers of this event, as well as to all of you attending. Human rights in law and life. Now that Nasser has squarely taken care of the law, I'm really only left with human rights in life. I'm going to pick up on a note, a provocation, a cadence of Alison's, and use my time to talk about slowness. So I'm going to try and cover slowness in 10 minutes. So I'm someone who's cycled through a few different relationships with human rights in my life. So I have been, maybe still am, an ardent believer in human rights as a vocation. I've been sort of a pragmatic and technical implementer. So human rights has been a tool for goals. For me, it was corporate accountability. So, for example, suing Shell for allegedly aiding and abetting state human rights abuses in the Ogoniland. I've worked with human rights as a social mobilizer. So found human rights to be a common vocabulary for different political groups, different movements, different ideologies, a common vocabulary that they can speak. And I've also been in my time a rather chastened skeptic and critic. So we've heard some about human rights for some but not all. Human rights as a tool of the powerful, the realist critique. Human rights as moral self-justification, the critique of liberalism. Human rights as highly provincial, for example. Through these relationships, a common theme that has emerged that I want to dwell on today has been the relationship between, simply put, research and rights. Sort of a set of activities and values that the academy might be particularly well suited to conduct and uphold. And really, for me, what is central to that is a reminder of the importance of slowness to human rights amidst its urgency. So it's important to say what I don't mean, which we're always reminded not to do. So this isn't sort of a curmudgeonly stick with which to beat others, a reminder that the ivory tower is where we should remain. And it's not an excuse to abstain from getting involved in what's urgent and pressing. Rather, it's a belief in the idea that it takes thought and slow thought to improve our grounds for meeting, for understanding, for judging in the world. And to the extent that you might think that human rights is a framework for this, and we've heard some thoughts about the importance of remaining skeptical about that, but to the extent that we think that, that is the ground from which I'm coming in my remarks. So what I want to do is just highlight 4 things that, amongst others, that I think human rights do, and think about academic slowness in their context. So I'll just think through these 4 things and talk about an example that sort of crystallized some of this for me in Sierra Leone, and I'll talk about why Sierra Leone. So the first is a focus on dignity and suffering. So human rights call on us to interpret the world through people's ability to live in individual and collective dignity, for some understanding of that term, and perhaps with slightly greater force to condemn people's experience of certain types of suffering. So human rights have a real urgency to them in this way, a call to alleviate suffering and pursue certain freedom wherever and however it might be found. Secondly, human rights at the same time also contain exclusions. So they produce exclusions of at the boundaries of what counts as the rights-bearing human. This may be individuals and groups who are historically denied the status of human and who still feel those legacies. This might include those whose integral whole or some part of themselves do not count as human today. It also, in the context of many movements, including the current climate crisis, includes things that are deeply entangled with human rights. So in the context of efforts to give rights to natural phenomena and ecosystems. We see in this, as we reflect, that rights get expanded, but they also get suspended, they get contracted, and they remind us of their boundary-making function. The third thing, rights make it very difficult to see, let alone make, trade-offs and priorities between rights. So which rights are more urgent? Whose rights prevail? This, I'm going to suggest, isn't sort of a counsel of despair or a sort of a pragmatic handwave away from a language and practice of rights, but rather that it makes making trade-offs a thing that we fundamentally struggle with each other to organize. So how do we make trade-offs becomes central to political life in a world of rights. So we come up with elaborate mechanisms of legal adjudication and political and policy compromise. We've heard many of them from NASA, quite an authoritative compendium. We also engage in violence, where different sides describe their actions in terms of the protection of their rights against abuses by others. And there's the constant background hum that some rights and rights holders are foregrounded. And I'm sure we can all recall hearing, perhaps even feeling some version of this. Why is the suffering and starvation of children in some parts of the world owing to poverty and civil conflict receiving less attention than those being killed directly and indirectly during war? Why do people refer to this as a gross rights violation, but not this? I'm not looking to answer these questions, but rather just to point out that human rights transforms our political lives in part into working out how to make and justify these trade-offs without losing the ideal of universal moral values at the heart of being human. And this is really, really hard. It demands a constant struggle to keep trade-offs in front of us as an enduring moral choice. And it's a significant moral and political act to decide the grounds on which we make the trade-offs. Human rights doesn't just do that. It doesn't just demand us to engage in this form of politics. It also calls on us to think about how we do so. Do we do so with charity or resentment? Do we do so with optimism or cynicism? Hope or nihilism? Passion or reserve? Finally, human rights challenges us to remember the consequences of our trade-offs as well. So from the indirect calculus of public policy making and cost-benefit analysis to the perhaps slightly more or maybe equally as brutal kinetic war, it reminds us that some rights are extinguished and foregrounds those who lose out. So never forget, it whispers to us. So I want to pick through these briefly an experience in the context of the emergence of the Ebola virus disease in Sierra Leone. There's a few reasons for that. One is it's just an experience that I lived through. It is also a slight effort to geographically recenter the discussion from the locus of concern that we might have had over the last few months. And also to move away or to recenter away from the rather kinetic concerns in the global north at the moment. So again, just an effort to slow down and recenter a little bit. So I'm just going to boil down a series of complex issues to one particular tension and trade-off that arose. On the one hand, the right to health and the other rights that went with it. Keep the Ebola virus disease from spreading across Sierra Leone, Guinea, Liberia at this point in time. Protect healthcare workers, keep health systems from collapse, which came, extremely close, if not did happen. On the other hand, a whole series of rights that were engaged in response and perhaps opposition. I want to focus on a series of cultural rights relating to traditional burial practices, such as washing the body prior to burial, which at the time was sort of fingered as perpetuating the spread of the virus. So the initial trade-off. Faced with the health emergency, there were straightforward efforts to restrict and ban these practices. The state, backed by the international community, and it policed, essentially, these burial practices, sent health workers and security officials to different areas of the country to remind people of this rule. It received significant blowback in some places, including provoking attacks on healthcare workers, and entrenched a further distrust of the state, in part because improper burial practices generate significant spiritual harm that produce material effects, failed harvests, for example. So a subsequent response drew fundamentally on long-standing, deep-standing, and slow academic and particularly ethnographic work done by Sierra Leonean anthropologists in the main. This was hard work, had not always been welcomed by state or local authorities, and as they were doing it in the context of the Ebola virus, at grave risk to themselves and others. And what this work did was bring burial practices and their thick meaning to the center of policy and legal debates over how to respond to this crisis. The colleagues, scholars in Sierra Leone, with some linked Global North researchers, imagined how to rework burial practices in ways that might be culturally sensitive but would decrease transmission risk, and had varying success in trying to encourage and disseminate these in various parts of Sierra Leone. The suggestion that I have is simply that this might be an effect of the ability of academics to slow down and draw on their past slow and deep thinking when responding to urgency. Going back to the 4 ideas about rights that I had, these scholars paused and broadened the suffering. They went from a set of medical rights, a set of medical suffering, to medical and cosmological understandings. They paused and broadened the inclusions and exclusions. The subject of rights was not just the individual whose health was harmed, but was the individual placed within the context of their ancestors and their lineage. Regarding trade-offs, they reminded us that there were trade-offs, real trade-offs that were occurring, not just a health emergency, and naming and invoking culture as an integral part of these trade-offs. Not only that, they kept those trade-offs open. Crucially, this wasn't just some innovative, hooray solution to a particular problem. They reminded us that the relationship between these rights was a set of trade-offs that endured and had to keep being made. So, for example, when COVID-19 then arrived, where frameworks from the global north around lockdowns were being promulgated to countries in West Africa, these scholars attempted to recenter and recontextualize these ideas within the Sierra Leonean context, reusing the idea of traditional burial practices, but also adapting them to prevailing mortality rates in Sierra Leone. So COVID-19 was not as severe in Sierra Leone as the Ebola virus was. And the anthropologists reminded us that reusing those burial practices from the Ebola virus was perhaps not necessary and would be perhaps an undue infringement on the slowly resurgent but fragile cultural practices that had emerged out of Ebola. And finally, they reminded us of who lost out from those trade-offs. They problematized and slowed down what they themselves had engaged in. So they reminded us of the political context of coming up with new burial practices within the broader framework of the relationship between traditional structures and the states. Their effort to find a middle way still kept customary authorities, customary chiefs in power, who, they reminded us, were also often economically exploitative and violent vehicles of local control. They continue to be, and this continues, the question of local authority continues to be highly politically fraught for community citizens, but also the academics themselves. So they continue to remind us not just to make the trade-off, but who might continue to lose out. So, in brief, it strikes me as today, thinking about human rights in life, that the academy must be engaged on human rights matters, and even more so on questions of academic freedom as a set of enabling conditions to conduct the sort of research that we're talking about. But I'm trying to point out how the academy plays perhaps a particular or specialized role in slowing down, broadening, deepening human rights debates. It can help us reflect on and contextualize the urgency of human rights, the prioritization and trade-offs between rights, but scholars can also take a step back to identify hard-to-see patterns of inclusion and exclusion, and to foreground and critique with moral force the identity of those who are made invisible as trade-offs crystallize, and the effects on the rights of those who lose out. Thanks. Thank you.
2 minutes. Thank you, Deval. Thank you, Nasser. I want to make a couple of remarks at the invitation of my 2 male colleagues who were very keen that a female colleague would also speak about human rights and life as part of the panel. I want to just make a couple of remarks around the work that I have been engaged in as a scholar of refugee rights and also as a human rights activist within the space of refugee rights. And I want to do it just by telling a couple of brief stories which all pertain to slowing things down. The first one is that in the early days of establishing a human rights network, looking at the work of refugees and asylum seekers within the Scottish context in Glasgow, the University of Glasgow hosted Dr. Al-Jafari, who was the first democratically elected Prime Minister of Iraq after the Second Iraq War. And during the course of a private discussion with Dr. Al-Jafari about human rights, and particularly about the refugee rights of Iraqis living and working in Glasgow and studying at the University of Glasgow, I had recourse to the phrase, a hermeneutic of suspicion. Now, that is a phrase that comes out of theological discourse in many ways, but certainly Gadamerian philosophy. And the interpreter, who was interpreting for Dr. Al-Jafari, was struggling somewhat with translating that phrase. And Dr. Al-Jafari had only spoken through an interpreter throughout the whole of his lecture and also the discussions. Whilst the interpreter was struggling, Dr. Al-Jafari was not, and he said to the interpreter what that translation was. And for a moment, I was outraged at the lack of efficiency, the lack of a need for a translator. Clearly here we had somebody who was fluent in English at the highest levels. Why were we therefore having to work through an interpreter? Until I realized that Dr. Al-Jafari was working in one of the most violent contexts in the world at that moment in time. And he, as a scholar and as a poet, as well as a politician, knew the need of slowing things down, of ensuring a double understanding in his mother language, the language of his state, and in his own and in English as well. And that it was important as part of equity, which is obviously sustained by human rights, that we too, as people used to only understanding things in English in a monolingual culture, would be decentered linguistically and would actually have the experience that is the majority world experience in these kinds of contexts of hearing things said not once, but twice, or maybe 3 times. So that's my first story. My second story pertains to a very small country called Eritrea, which is in the Horn of Africa, for those of you who don't know. I didn't know where Eritrea was until 15 years ago. If you'd asked me to point to it on a map, I'd have said, yeah, you know, somewhere over, I don't know, probably down the eastern seaboard of the African continent. Until volunteering, as I did at the time with an organisation called Positive Action in Housing in Glasgow, a young unaccompanied minor came to stay in our home. Whilst we were waiting, we were told it would only take 2 days for her asylum claim to be sorted out, were the phrase that the charity used. And one of the things she did with us was sit and point on an atlas to where she was from. We had no language in common. We were needing to phone up an interpreter to speak and, you know, decipher what on earth it was that these weird white people had in their fridge that we were offering her to eat. On Monday this week, that young woman, now our daughter, gave birth to our 3rd grandchild. She comes from a country where there have never been human rights in the entire existence of that country, where the 30 Years' War, which preceded the independence of Eritrea in 1992, was followed without a ratification of the constitution, with no institution of human rights, where the University of Asmara was closed down in 2003, and where there is no system of higher education. So she has raised for me, as a daughter, many questions, as children do, but one of which is, what does it mean to bring people in to that system of human rights that transforms our lives, as Deval has said, that system of justice as social production, when for the first 15 years of her life, that was not a system of social production or understanding or touched her life in any way, shape or form as part of the international order. And I have no answers to that question other than that gradually, as part of the process of education within Scotland, an awareness comes of what it might mean to be a rights-bearing subject, but that many refugees will impress upon me the importance of understanding that the majority world do not feel that they enjoy what it might mean to be rights-bearing subjects, and this is the reality of their life. And rather, as Deval was saying earlier, I don't have answers to that as a question other than to make sure that I speak about human rights as something that we are privileged to enjoy, and that I believe that means we have a responsibility to continue to uphold. And my final example comes out of the experience of working in Aotearoa, New Zealand. And I use both those names for that country, Aotearoa being the Māori name for New Zealand. I'm working with Tūhoi Māori who impressed upon me the importance of telling about their story. Tūhoi Māori had worked under the Treaty of Waitangi, O Te Tiriti Waitangi. The Treaty of Waitangi exists in two forms, Te Reo Māori and English. They are not translations of each other, and yet all of the Pākehā, the fair-skinned population, the white settler population, and of the indigenous Māori population are bound to uphold the Treaty of Waitangi, as are visiting researchers at universities, as I was. So when I arrived, I was asked to sign a document that said I would uphold the Treaty of Waitangi. So my question was, well, which one? Is it O Te Tiriti or is it the treaty? And what would that mean? So I asked my colleagues, because of course I didn't have an answer. And that of course slowed things down a wee bit while they discussed in Te Reo Māori and in English what that might mean. And all of them asked me to learn Te Reo Māori the Māori way. So using a very different form of language learning to any that I have experienced or used in my teaching practice. And also to really understand what it means to be people of treaty when our treaties do not agree and are radically incompatible. And yet by accepting that radical incompatibility, what my Māori friends and my Pākehā friends were telling me was that it was possible to begin to open up a slow space for a different set of questions and determinations about what we might mean by rights. And that into that, Māori have also inserted the question of legal personality of the land and of the waters, of the river and of the forests, and that has raised other questions for us that I think are really pertinent in questions of climate justice today. So I hope that my colleagues feel I've done justice to their request that I too speak. And I'm now going to invite both Deval and NASA to join me on a panel and open out the floor to question and answer. Thank you. I understand we have a couple of roving mics, and there are glamorous assistants running around with them. So if you have questions or comments that you would like to ask to the panel, particularly to Deval and NASA.
Particularly to Deval.
And obviously, you know, Deval is now passing all legal questions to NASA and vice versa. But yeah, I'd just like to open this to the floor and also to our colleagues online. Yeah, a question over here. Yeah, if we can just wait for the mic to come so that folk online can hear well, because the mic system's making sure they do. Thank you. And maybe if you could say your name, introduce yourself.
Okay, thank you. My name's Callum McFadgen. Don't have a particular strong academic background beyond doing social policy as an elective in first year at university. But I want to raise a couple of points about the rights of children in our Western societies. When I was 9 years old, my parents split up in a very acrimonious situation. And that was around about the time when the United Nations Convention on the Rights of the Child was signed by countries all over the world. Yet in the UK, it was never ratified by the UK Parliament. And quite recently, we've had the situation of the Scottish Parliament voting to enshrine this into Scots law, and the UK Parliament opposing it. And at the time, I wanted to intervene in the divorce process between my mum and my father over the access issue. And the lawyer involved invoked the United Nations Convention on the Rights of the Child. But the sheriff at the time obviously didn't want to go down the road of making any comment on something that hadn't actually been enshrined in law yet and create a precedent. So he spoke to me personally in his chambers and agreed a situation where me and my brother could decide for ourselves. And that took the whole access issue out of the divorce process, which was absolutely fantastic. But I see across Europe and some other countries, and I want to focus on in Denmark, where the rights of the parents were always put above the rights of the child. And there was situations where abusive fathers were asserting the rights to have the child stay with them in a 50-50 split for custody. And that meant that the state was essentially forcing a child to live with an abusive parent. But not only that, splitting, even when the parents weren't abusive, splitting them between two places, two different households. There's the instability in that. And it affects schooling. They might have to go to school in two different places. So we're now at a situation where that was over 30 years ago, yet hasn't been implemented in a country that's supposedly a democracy, in a place that has supposedly rights. And the second point, again, reflecting on children, and quite appropriate given the recent increase announced to the minimum income requirements for family visas and the costs for that, and the way it affects children. Now, in our situation, my wife's originally from Crimea, was living in Russia at the time we were expecting our first child. We'd applied for the visa to come over here on a priority basis. That didn't quite work out quite that way. My little boy was born in Yaroslavl, not far from Moscow. Yet, for the first year and a half, they weren't allowed to come over here. The visa application was denied. I didn't earn enough, essentially. I wasn't rich enough to have my child, who was a British citizen, to live in this country with me. And he, even if my son had come over here, which he was entitled to, he had a British passport, he would not have been allowed to have had his mum live in this country. And in the European Convention of Human Rights, Article 8 is the right to a family life. How is that compatible with what's happening now? And the minimum income requirement has jumped by more than 100%. It's gone up to a point now where it's above the median income for the entire UK. I think only the top 40% of earners can actually afford to have an international family here now in the UK. So I guess the question that I want to ask, what's the point of having rights if governments can simply just ignore them and can just price people out of it? And then in the case of Rwanda at the moment, they're trying to legislate to override our own Supreme Court.
Thank you, Callum. Thank you very much. Which of our panellists would like to take that on first?
Go on.
Go on, Devon.
I mean, first of all, thank you. There's so much in it. But.
Yeah, so much in it.
This is where the very, very, very apparent limits of my legal technical knowledge emerge. Another way of saying that is I'm very grateful at the same time that we have a lot of, that I personally as well have a lot of colleagues at the University of Edinburgh who are doing pretty remarkable work, just trying to tease through slowly and carefully what exactly some of these problems might mean. So this I'm trying to set up in contradistinction to, I'm never really sure what the phrase is, but sort of left-loony lawyers and left-loony academics or something. There's some set of phrases that get thrown. So my colleague Casey McCall-Smith has done some crucial work trying to understand how and why the CRC, how the CRC may or may not get incorporated within Scotland and other colleagues who have been working on the constitutional issues, all of which are sort of motivated, I think, by that idea that whatever rights might be, they are fundamental to understand not just as aspirational, but also as frameworks that get implemented always imperfectly and always fuzzily, but are crucial to keep trying to work at initially at the edges of and to keep on pushing.
I mean, I don't have a single answer to the question because the question doesn't have a single question within it. It has several. I mean, the part of the question which concerned the implementation of supranational treaty obligations or their domestication in law is also partly a question of governance. And I'm looking at Michael on the front row, who is exceptionally well qualified to talk through the multi-scalar character of that and the ways in which the devolution of settlement means some things fit and some things don't. But I think there's probably a prior question behind that, which is about political will and a desire to domesticate some international treaties rather than others. I mean, the related issue about thresholds, income thresholds, the tightening of entry criteria is not new, recent. If anything, it's been on the horizon for a long time. There's just been a rapid acceleration or uplift of the threshold. And those of us who work on migration have for a long time been pointing out the inequities within the migration system and the increasing penalization of the right to a family and family reunification. From the high point of 1997, where the incoming Labour government revoked the primary purpose legislation, which was in place to prevent family reunification, especially transnational marriage, that you couldn't come to the UK if that was your primary purpose. We've just gone backwards, I feel, because it's seen as a soft target for reducing numbers of inward migration. But that's all I have to add on that.
Yeah, there's some really key discussions, I think, going on in Scotland at the moment around the Human Rights Bill and which elements can be brought into Scots law of Human Rights Convention and various different treaties. And of course, there was an attempt with, I'm looking hard at Deval here, who might be able to help me, but on the Convention on the Rights of the Child, there was an attempt to bring that into Scots law that was then thrown out by the Supreme Court, if I remember, and that's now coming back for another go, all of which seems to be bound up with questions of how complicated our constitutional arrangements are in technical legal terms, but which I think throws back on us this question which we're addressing today of human rights in life, because what you've described to us, both those stories are ones where under the Universal Declaration of Human Rights, you have rights and they are present, and yet you're not yet seeing those being brought into various sovereign contexts. And that is the space of action and activism, of campaigning, of justice work. And particularly when I saw the hike yesterday in the minimum income requirement, immediately the words love tax flashed into my head, because that is the name that Migrant Voice, the amazing campaigning organisation, has given to the previous thresholds that have operated, which were also almost unworkable for many groups. And that basically, there were already campaign slogans being generated, which were around things like, British spouses for British lives. So really, highly cynical language being used around what this will actually mean. And so I do think, for me, when I see the latest set of suggestions that come out from the government as to these administrative changes, which don't necessarily go through an act of parliament, but where there's a kind of just a decision to just do something else which will further make life difficult for particularly migrant groups, but also groups who might be disabled or for children. I'm thinking of age assessment legislation that came through with the Illegal Migration Bill and the Nationality and Borders Act, that it's then for me a question, yes, there's a political process, which will be a slow process, but what might be the processes and the groups that we can form as alliances to try and find ways, both in law and through politics, to make sure that we prevent some of those, the worst effects of those actions or reverse it. And we do see reversals. It's not all doom and gloom. Yeah, please do, Deval.
So there's a particular policy context here that I find rather puzzling as well around the increase of the minimum income threshold. So shortly before this was announced, the Foreign Office released its rather ballyhooed aid white paper, within which several pages are dedicated to the importance of remittances to, essentially as a moral justification for, or part of the moral justification for the aid white paper, and implicitly for the government's temporary lowering of its aid commitment in its budget. These remittances are actually reasonably directly tied to a set of policy goals for the government, which entail reducing conflicts, promoting the rule of law, and upholding human rights in countries with which it has a development relationship. Couldn't help but think that when the income requirement shifted quite significantly for visas for entry into the United Kingdom, the impact that that might have on those remittances that are a central moral plank for not just the aid policy, but also in the government's terms, rights realization in its developing country partners.
Thank you. That's an angle I certainly hadn't yet got to myself. And thank you, Callum, for that question. Further questions from the audience?
Question online
Yes.
from Alistair McIntosh, who asks, does the panel have views on international aspects of human rights? I'm thinking of the way in which bygone trauma that could not be digested arguably shapes the psychological and spiritual fields.
Could you just read that again?
Does the panel have any views on intergenerational aspects of human rights? I am thinking of the way in which bygone trauma that could not be digested arguably shapes our psychological and spiritual fields.
Thank you, and thank you, Alistair, for that question. So intergenerational trauma and how it shapes human rights. Yeah.
Right.
NASA.
Okay. Well, I mean, there's a reparatory character to that in terms of the appeal to post hoc legislation, which is meant to offer some kind of compensation. So, one illustration. Colleagues who are British by birth and whose parents are British by birth, but whose grandparents were either victims in the Holocaust and or survivors and or refugees in the UK had access to pathways to German citizenship restored. So a number of my colleagues, some of my friends who had a German Jewish family historically were able to appeal to that corrective measure to remain members of the European Union, to have a passport which allows them to still be in the EU. But in addition to the smile it brought to my face, and obviously it spoke to a deeper, long-standing historical wrong that was trying to be redressed in some small, infinitesimally small fashion through the means of access to German citizenship today. And that proceeded on the basis of a human rights claim in Germany, which wasn't something that I'd necessarily thought was plausible and or could be operationalized in that fashion. And the question that follows from that is that if we can do that in that case, in what other instances could that logic work too, in the context of post-colonial societies? Now that's an open question which seems to generate more hostility and opposition.
I'm happy to, okay. I guess two other reflections. One, I think, simply on, reflections from colleagues who worked with the international criminal tribunals in Cambodia, or the hybrid tribunals in Cambodia, following the Cambodian genocide, and the work that many had done to track how the genocide really fundamentally reshaped political relationships. So one effect that some legal anthropologists had tracked was a shift to a fundamental desire for protection that could be mistaken for patron-client relationships, but was fundamentally about seeking protection in local spaces from what sometimes manifested as strongmen. And the reflections from then that my practicing colleagues were around the particular set of challenges that posed beyond the ordinary of trying to, in their terms I have a slight problem with, promote a human rights culture and context, or promote human rights awareness, in essence, in parts of the Cambodian context, that generational and intergenerational legacies of past trauma can lead to a range of different political orientations, not all of which are necessarily a clamour for what we might understand as liberal human rights. Actually, I'll pause on the other thought, the sort of intergenerational justice and climate change, but that's probably a bit too much to chew off, to bite off right now.
Yeah, though knowing Alistair as I do, I think he'd quite like that angle too. So we might come back to it. I wanted to reflect a little bit around that with two thoughts. One is that around 15 years ago, when I began working particularly intensely around areas of refugee determination, medical assessments of trauma were often required for those determinations. And it was very clear that the Home Office guidance was not really in sync with medical opinion as to what constituted the manifestations that were possible when someone was experiencing trauma. Now, this isn't the intergenerational elements, these were direct elements. And I feel in the last 15 years, we've really come a very long way in our understanding of trauma, but also, and this may not always be helpful, in a almost democratization of what trauma is. So that trauma is now something that's part of everyday speech. We talk about it a lot. We will quickly maybe explain things as trauma that may or may not be formed by trauma. We may quickly move to speak of intergenerational trauma, particularly in contexts of past genocides and in contexts of colonial harms, and that our understanding of what those constitute or what they are is often a lay understanding that perhaps could benefit from the kinds of slowing down and academic eye and disciplined understanding that I think we're really opening a space for at the moment. And I've thought about that in the context of two pieces of scholarship, one by my colleague, now Professor Ross White, well done, Ross, who is a clinical psychologist and scholar who has worked on a number of different areas of human rights abuse in Sierra Leone, but also in the Rwandan genocide. And one of the phenomena that he writes about in his work is the anniversaries that were held to mark the Rwandan genocide, and that a form of psychosis might overcome people at that time with a kind of acting out or a redreaming of what that was, and that would not just be present in members of the population who had experienced the genocide, but would also be present amongst members of the population who were born after those events. And he was really interested in that clinically as a manifestation of psychosis. But I think it also then raises questions around what we do during memorialization, and perhaps whether our assumption that all memorials are going to help may be one we also have to subject to some critical understanding. And the other scholar is the late Gillian Rose, the philosopher, not the visual geographer. The philosopher, the late Gillian Rose, who was a great influence on the scholarship of Rowan Williams, the former Archbishop of Canterbury. And she wrote a book about Holocaust memorial work, and she looked particularly at the Auschwitz memorial work. She looked particularly at other forms of memorialization, education and commemoration around the Holocaust. And she wrote quite a short book, and it's actually one of her more readable texts, called When Mourning, as in MOURNING, becomes the law. So she looked at the way that around Holocaust memorial, there was almost a requirement to feel it, to experience it, to never let it go, to always have it by your bedside like a packed suitcase, to make sure that no one ever forgot, and to be aware that it's always just around the corner. Now, her concern was that that may be something philosophically that is enabling a trauma to continue that may not necessarily serve every generation, and may be part of what we are also experiencing at the moment around the genuine fear in society as to how we talk about events we didn't live through, how we speak about great acts of colonial harm, the Mau Mau, for example, how we approach apology, how we approach memorialization, and whether those times of memorialization might actually be doing more harm, including with the carrying of intergenerational trauma and knowledge. Nasser?
Just one thing stirred by your comments and Dival's and the question too is that, I mean, the common parlance in talking about the kinds of mass violence, may well be things like ethnic cleansing, which, doesn't have a legal technicality to it. It's much more of a register used to describe a historical, modern, contemporary feature of state violence and actions which have the character of genocide. But genocide has a legal standing. It has implications. It carries with it not only a moral force, but a requirement for redress and recognition by the state party and or other people involved, through which then claims can be made. And it's notable that a lot of the people who work on trying to curate and remember the ethnic cleansing and or the violence / genocide in Bangladesh, will mobilize partition, West Pakistan, East Pakistan, West Pakistan becoming, East Pakistan becoming Bangladesh, because they want a formal recognition that violence was a form of genocide, and that the Pakistani state is culpable. To be able to then curate it, to memorialize it, remember it, to recognize it, that's 2 generations away. And so there is almost a live dispute, a contestation in seeking recognition for relatively recent episodes of mass violence, which pivot sometimes on the technical designation of it as a genocide rather than a form of ethnic cleansing. Yeah.
I mean, an implication of that, returning to our overall theme, is we've spoken about human rights in terms of their universal and egalitarian character, but also to the extent that they're an important register to make claims that the formalization in law travels through time in a really important way that perhaps other means of formalization, political consensus, for example, might not.
Yeah.
Which, as a lawyer, I would contest.
Yeah.
But
yeah. And that within all of this, there is something, again, that I think we're really at quite an early stage in understanding, which is what it is that apology and what it is that truth and reconciliation commissions can do. And clearly following the South African apartheid, the TRC, the Truth and Reconciliation Commission, was a powerful body, and also one which is highly contested as to its efficacy, as to what it was able to bring about. But there have been other Truth and Reconciliation Commissions, around the rights of the First Nations people of Turtle Island vis-a-vis the Canadian government, the Lost Generations, the apologies made by Prime Minister Gordon Brown when he was Prime Minister towards the Lost Generations in in Australia particularly. So there's a number of places where apology is used as a way of enabling perhaps a moment of redress for what are intergenerational traumas and ones which are still felt within the bodies of those who've inherited these as part of the stories they live in. But I think as scholars, we're at a very early stage in understanding what truth and reconciliation and what the power might be of apology and the importance of processes of justice in addressing intergenerational trauma. I'd like to maybe open back to the audience to see if there's a question at the back there. Yeah.
Thank you, Moira Lang. It's a tricky question because I'm loving the conversation. I'm loving what Alison and others and yourself have said about slowing down the dialogue, thinking, reflecting. But with my other hat on, I'm a doctor. I'm an academic, but I'm a doctor who works in Gaza, and I've just had a flood of texts and messages. And I'm talking to a lot of colleagues I come from a palliative care background where compassion, suffering, what does that mean is part of our dialogue. But I'm talking to my surgical colleagues and my anaesthetic colleagues. And where does the intersection between the very important, slower reflection, which is vital, and I've benefited today just from slowing down a bit and listening, where does that intersect with an acute crisis, with calls that there may be, or some would say there is, genocide happening, and where does the brilliant academic focus come in those more acute settings? Thank you.
Where everyone's looking at each other. Maybe I'll go first, Moira, because I know that you and I have had conversations today, and that I too I have a phone full of messages from colleagues in the Gaza Strip, having worked with colleagues there for the last 15 years. But I'm also acutely aware of a good friend of mine who lost one of her best friends in the attacks on the 7th of October, and that people are in a place of acute grief at this moment in time, but also acute need to slow things down and stop, and to the point of stopping them within the needs for a call for a ceasefire. So maybe one thing I would say is that I would commend to everybody a wonderful book by Elaine Scarry called Thinking in an Emergency. And I cite it regularly. She is Harvard Professor of Thought. Wouldn't you just love to be a Professor of Thought? And she wrote this as her Amnesty International lectures, I think back in 2010 or 11, I may be wrong, to really address her concerns after 9/11. At what she had seen as the setting aside of due process, due parliamentary process, the processes of law, and the bringing in of emergency powers, states of emergency, what she called emergency thinking that was not well formulated and had not been subject in different times to careful analysis. And I found her book, it's wonderful. She talks about the American Constitution, firefighters in Canadian grain storm fires, and the man who is tasked with looking after the cultural artifact that is the relic of St. Gallen, in Zurich Cathedral. And she puts these three case studies together and then really makes a plea for us not to set aside the legislation, the treaties, the thinking that others have been able to do in rooms like these and on days like these, when we've really picked over what we mean, when we've found definitions, and through that been able to lay down in codified ways and in guidance and in guidelines how we might act were the unthinkable to happen. Now, for me, that's been extremely important ever since I heard her lecture and I heard her speak, to thinking, how do we make sure that when there's an emergency, we don't just make it up because our gut tells us we know what is right, because our gut is often wrong or it needs other perspectives. And it's that, head, heart, action element. And I think in many ways, in medical practice, you spend a lot of time training, thinking, learning, and then turning that into an action that can actually save lives so that you can put that into practice. you don't, when you get each new case, go, right, we're setting all that medical training aside, we're going to ignore it, and I think I know what to do in order to save this life now, but it's not going to be what anyone's ever told me to do previously. So I think that's there within the medical practice too, and for me, that's where I go to. And whenever there's a bit of any crisis involving refugees within Scotland, my phone is red hot, and usually my first counsel is to say, slow it down, stop, think. What does it actually say? What does the law say? What do our statutes say? What do our policy documents say? Let's start from there, and let's start from the wisdom that has prevailed up until now, because it's better than what we're going to make up on the spot. So I think that's what I would say. In an emergency, there is a need for us to almost rush to what has been laid down for times like this. Yeah. But Deval or Nessa?
I mean, my sister's a clinician. She works in palliative care in this country. It's an impossible job. To do it in a conflict setting, in a live conflict setting, is unimaginable. And the limits of my experience and and our scholarship, quickly comes to the surface in these contexts. But what I would also say is that we have in place statutes to prevent this, and if nothing else, academics, 800 of us, universities should be the first to point that out. Distinction, proportionality, necessity, human treatment. This is there for a reason, and the reticence, dare I say cowardice at times, will be our stain, and a reflection of our inaction, and we'll have to take ownership for that.
So I think I might distinguish between, through a very rough distinction, between three different things that we might do within the academy, understood sort of broadly. One might be engagement, political engagement, engagement with the world, and the exercise of judgment. So I sort of imagine that as general civic participation, but something that perhaps we train ourselves in to some degree. And here particularly I'm thinking about the funding state of the arts and humanities, but also the centrality of the arts and humanities too, that sort of training. Then there's a second type of thing that we might do, which is knowledge and its application. So there I might imagine us engaging in urgent ways, but on the back of the slow thinking that we've done before. So we've gathered knowledge and we're trying to apply it. So it's sort of analogous, I think. It's roughly analogous to what Alison was saying. Then the third is inquiry, which I think I would distinguish, right? And that is stepping back, asking questions about the questions, thinking about the framing. And so these are not mutually exclusive. In an ideal world, these interrelate. These are all things that we struggle with, different registers that we operate and live in, but that we certainly shouldn't lose sight of cultivating all three of these. And I think I hear in your question a call to do some of the second, but more of the first.
Thank you. Thank you. We are up to time. Aoife is tapping her watch, which is her signal to me to bring this to a close. I want to thank all of the members of staff at the RSE, because there is, of course, a team of people working on this, and particularly Aoife, who has drawn all of this together and all the arrangements and organisation and organising of her colleagues. So if you could give her a round of applause, please. And I'd also very much like to thank members of the Human Rights Committee for the UK and Ireland who do a really sterling job of reading a lot of alerts and really holding the academies to account for their support for those who are at risk. It's important work, it's more important than ever, and I think this has been a really wonderful day for us to come together in person to discuss these matters, but also to have you all with us today. But before we finish, I'd like to thank Deval and also Nessa for joining me on this panel today. And I'd like to leave you with the words of the poet Ingrid de Kock, and the words that she used after the first sitting of the Truth and Reconciliation Commission in South Africa. And she says this, and I think really brings it into the focus of human rights in law and life. And she writes this: "The Archbishop chairs the first session," by Ingrid de Kock. The Truth and Reconciliation Commission, April 1996, East London, South Africa. On the first day, after a few hours of testimony, the Archbishop wept. He put his grey head on the long table of papers and protocols, and he wept. The national and international cameramen filmed his weeping, his misted glasses, his sobbing shoulders, the call for a recess. It doesn't matter what you thought of the Archbishop before or after, of the settlement, of the commission, or what the anthropologists flying in from less studied crimes and sorrows said about the discourse, or how many doctorates, books, and installations followed, or even if you think this poem simplifies, lionizes, romanticizes, mystifies. On the first day of the commission, the Archbishop laid down his head and wept. There was a long table, starched purple vestment, and after a few hours of testimony, the Archbishop, chair of the commission, wept. That is how it began. Thank you.